Okay, here we go. Hello again, everybody. My name is Natalie, and I'll be your moderator for this segment. For those of you just tuning in, this forum is hosted by the Associated Students of Western Washington University and the Office of Civic Engagement. Our goal is to activate students towards becoming informed and involved participants in the political system. For everyone here live, you can submit additional questions for the candidates that may be answered at the end of each segment, time given. Simply find and click the Q&A button in your options bar to submit a question. This segment of the forum is for the position of the Washington State Supreme Court Justice, positions 3 and 6. I'll be speaking with candidates Dave Larson, Raquel Montoya-Lewis, and Richard Serns. So thank you all so much for being here. We're going to start off by giving you time for a short introduction, starting with Judge Montoya-Lewis. You have 1 minute and 30 seconds, and you can start when you're ready.
Thank you, everyone. I appreciate the opportunity to be a part of this debate. I was a part of the Western Washington University community for 12 years as a professor at Fairhaven College. So it's a nice opportunity for me to return and hopefully be able to address student questions about this most important election. I'm the first Native American to be appointed and to sit on the Washington State Supreme Court, and only the third Native American to sit on any state Supreme Court in the country. I appreciate and understand the historic importance of my appointment, but I think that more important than being the first is that I not be the last. It is critical to me that in my work, and this has been a part of my career, my entire career, that I work to bring people along with me. I've been a trial court judge for 20 years. I have presided over misdemeanor trials, traffic citations, child custody cases, felony murder trials. I have seen it all. And throughout that, I have had student engagement and student involvement in many different ways. That has been an important part of the work that I've done. I look forward to being able to continue to serve in this role on the Washington State Supreme Court for the next 6 years, and I look forward to receiving your vote.
Thank you. Mr. Larson, go ahead next.
Hi, I'm Judge Dave Larson. I've been a trial judge for about 12 years now. I was a trial lawyer for 23 years before that. First of all, I want to make sure that you guys know this is the most professional debate we've had this whole time, and it's wonderful. The timer, the feel of this, it's just great. And I have a passion for the types of things you're doing. In 2014, I got the Judge William Nevins Award from the Judges Foundation for my activity in civics education. But we have a short period of time to explain why we're running, and I'm going to explain why. Because the justice system, I've been involved in the justice system for 39 years in law school, as well as a lawyer. I worked full time and went to law school at night, and I worked for the prosecutor's office in Pierce County for 2 years, and then worked for a private firm for 1 year. Became an AV rated trial lawyer, which means my peers thought I was preeminent in what I did, and then an exceptionally well qualified trial judge. Best thing I did was become a trial judge because it can impact people's lives, but it's also the most frustrating. There's a lot of things happening to our communities and a lot of people getting hurt, and we don't do enough to in the judiciary to look through the eyes of the people we serve. And the reason I'm putting the passion in to run for this and running statewide is because I want us to have more attention to the people we serve, the people we're failing every day, and that's one reason why I'm running. So I just appreciate the opportunity to address you this evening, and it's just great that what you're doing. Thank you.
Thank you. Mr. Serns, go ahead. Oh, looks like you're muted. I will go ahead.
Okay, there we go. Good evening. I too want to thank you for the opportunity to be here. I spent many happy days at Western as a recruiter for the Federal Way School District when I was recruiting teachers, and also did some HR training there. Also got my superintendency endorsement from there. So I wish we were there in person, but this will have to do. As others have mentioned, a minute and a half isn't much time to tell you about yourself. but I'd like to explain that my background's very unconventional for this position, but I'm offering myself as an alternative, and I think that's healthy with as you no doubt know, there's 9 justices on the Supreme Court. It strengthens the court to have a variety of perspectives, a lot of diversity of thought and experience, as well as other types of diversities. I started out as a teacher and a principal in K-12 schools, got an interest in law, got a PhD in educational policy and management. My dissertation was in education legislation in Washington State. Then I went to law school, got my JD from the University of Washington. I then worked for most of the last 20 years in human resources, where you have a lot of experience in all different aspects of law. I was the lead negotiator for collective bargaining. I was Title IX officer. I was compliance coordinator for anti-bullying, harassment, and et cetera, et cetera. I'll hope to share with you more. Look on my website for more information. Thank you.
Thank you all for your introductions. All right, we're going to move right into our first question. And we will start with Justice Montoya-Lewis to answer this first. So our first question is, what actions will you take to improve Washington's justice system? And you have 1 minute and 30 seconds.
Thank you. I've been working to improve justice systems for my entire career. For the first 15 years of my work as a tribal court judge, I worked on systems that were very well developed, and I worked on developing legal systems from the ground up. So I have a great deal of experience in serving the needs of communities and thinking about alternative ways to address the problems that bring people into the courts. On the Washington State Supreme Court, I have the opportunity now to be a leader in the state of Washington as we move forward with reforms. We have passed General Rule 37, which addresses how to address juror bias and juror selection. Throughout the COVID-19 pandemic, we have been addressing issues related to access to justice. My driving passion and the work that I am a national leader on is teaching and training judges on how to assess implicit bias and how that implicit bias impacts their decision making. It impacts all of our decision making throughout our day. But when we are judges, people's lives are in our hands, and it is our responsibility to understand how those implicit biases, which we all hold, impact how we rule. And that's an area I intend to be a leader on in the Washington State Supreme Court.
Thank you. Judge Larson, you can go next.
Thank you. That's a great question. And I think the contrast I have with Justice Montoya-Lewis is that she's, I think, what she wants to do is very well regarded in the judiciary. But the problem is we're not doing enough to look through the eyes of the people we serve. For years, I've been in this system for a long time. On the issue of race, Justice Madsen wrote an op-ed in the Seattle Times 10 years ago saying we need to do things. But what ends up happening is we have task force commissions. We go through a number of trainings as judges on implicit bias, but nothing changes in the system. Nothing changes how we interact with the people we serve. We need to have a complete overhaul of our criminal justice system and our family law system, and we need to start with having a therapeutic approach first and a punitive approach second. And that's what the problem is we're not changing anything for the people we're actually serving. So under Justice Montoya-Lewis's model, at least the judges will understand why people are upset with us from a cultural standpoint, but we actually have to better serve the people. Right now we have a Gender and Justice Commission, a Minority and Justice Commission, but we need a Behavioral Health Commission to deal with the addiction and mental illness that's affecting so many people. And we need to start focusing more on the people we serve instead of ourselves. And that's my frustration over the years is we spend a lot of time as judges looking at the judiciary, but not the people we actually serve. Thank you.
Thank you. All right, Mr. Serns, you're up.
Also a great question. I think in my work in education, I've had a lot of experience with problem solving and working on committees and looking at things. And I think a lot of times committees get established, commissions get established. They talk about all the right things, but they don't sustain it. And I think the steps that need to happen for any improvement is cyclical. And you need to start with IDing the problem. Inequity is perhaps the biggest problem that we face in our entire criminal justice system. There's a lot of commissions in place. I want to work with those that are already established. I think we second, after IDing the problem, we need to make sure that all people have a voice. Every stakeholder is heard, and listen to people that are impacted by the decisions that we make and the commissions that we set up. Listen from them. A lot of times you can learn a lot from listening to all different perspectives, not just your favorite one. And I think then you study, you act, and then you need to see what's working and what isn't. And then you go back and start all over again. You reevaluate what's working and what isn't. You ID the problems that you need to work on further. You continue this giving feedback and working with all stakeholders and moving forward that. It's never ending. We need to constantly improve.
Thank you so much. All right, on to our next question. And for this question, we will start with Judge Larson. Everyone still has a minute and 30 seconds. And the question is, when it comes to interpreting the law, do you prefer to interpret based on specific wording or understood intent?
Well, it's not what I prefer, it's what the law requires. And when you're looking at statutes, you're supposed to look at the plain language, the plain meaning of the words, and apply them the way they're written. You do have to look at the intent. If there's ambiguity or vagueness or those kind of things, then you start looking for legislative intent or intent in terms of looking at the meaning of that statute. But the reason that's so important is that you as an individual, if you look at the law or you talk to a lawyer and they look at the law, you got to be able to predict your behavior. And if you're left to somebody, a judge that can second guess the plain meaning of the words, then you fall victim at that point to you may end up paying consequences you never intended. So it's very important that judges read the law the way it's written first, apply the rules of construction that have been well established for years that allow you to look to intent after the plain language fails. And that means the legislature's got to do a better job a lot of times in passing laws that everybody understands. Sometimes the courts are saddled with interpreting laws that are unclear. But those are the rules of engagement. And as a judge, you have to follow them. Even if you don't agree with the outcome of the case, you still have to follow those rules or else you become a tyrant and you don't want to do that. So that's it. Thanks.
Thank you. All right, same question for Mr. Serns. Go ahead.
Well, I think the question of judicial philosophy is very important. And sometimes when I've been questioned about my particular unconventional experience, it's been suggested that a person with more experience in the judiciary will make it come to a better decision. But I think it's the amount of time you spend in the judiciary does not determine the outcome. An example I always use is Justice Ginsburg and Justice Scalia had comparable experience, but they disagreed on the outcome very often. And that comes to the heart of your question, what is your judicial philosophy? At the one end, we typically call it originalist or strict constructionist, very carefully narrowly looking at the Constitution and the laws that flow from it. The other end is viewing it as a living document where you may look at intent, look at times that are changing and so forth. I don't think typically anyone is totally one or the other. I think we're all somewhere around that continuum. I believe both is important. I think you always need to start with the plain language. Then if that's not clear, you need to look at possible intent. I guess I would categorize myself as somewhat of a centrist with judicial philosophy. I'm certainly not, I don't think I fit into a neat box of conservative or liberal, and I haven't identified as a Democrat or Republican for many years, but I just want to look carefully at the law, precedent, and common sense.
Thank you. Justice Montoya-Lewis, go ahead.
Ali, would you mind repeating the question for me?
Absolutely. Thank you for asking. The question was, when it comes to interpreting the law, do you prefer to interpret based on specific wording or understood intent?
Thank you. I think a combination of the two generally would be the way that I approach a case. Sometimes we don't have clear meaning in a statute or in the case law that we're interpreting. If there is plain meaning, it's very clear that that's what we should be doing, interpreting the plain meaning, applying it to the facts, and making a determination from there. But if it were that easy, we wouldn't have a job on the Washington State Supreme Court. The courts of appeals would take care of that and things would move on. What we see on the State Supreme Court is usually where it is a complicated tension between what the language of a statute or the Constitution says and what the intention might have been behind the statute or the Constitution and the circumstances that are in front of us in terms of the factual circumstances of the case. Our job is to be able, among the 9 of us, to discuss all of those aspects of the case to arrive at an answer that is one that is the correct legal answer, an answer that is pragmatic and will work in the courtroom, and an answer that makes sense in terms of what the law has been and what it should be.
Thank you all so much. And I just have to comment that the 3 of you are really excellent at keeping your answers exactly within time. And I absolutely appreciate that. All right, so on to our next question. And for this one, we're going to start with Mr. Serns giving our first answer. So
May I say something on behalf of Dr. Serns? He's a doctor.
I'm so sorry. Thank you for letting me know.
Mr. is fine, but thank you.
Thank you so much for that correction. I appreciate that. All right, so Dr. Serns, you will be addressing this question first. And the question is, what actions will you take to remove structural inequities and systemic discrimination from Washington's justice system?
Well, I think first of all, you need to be aware that it exists and be knowledgeable about the problem. And then of course we need to listen. We need to reach out to all stakeholders. I think we need to seek more funding for public defenders. I think I'm fairly accurate on this. I'm not sure exact details, but I've heard something as high as 80% of African Americans who are charged with crimes have public defenders, and the caseloads for public defenders are very high. I think we need to try to get more funding so we can have more public defenders, pay them better, and not have as big of caseloads. I think part of it is being a role model and being a leader, recognizing the problem, speaking about it every chance you get. I was looking at another question that I was anticipating the answer, so excuse me for pausing on that, but I think I'll yield my time on this one. Thank you.
Thank you. All right. Justice Montoya-Lewis, you're up next.
Thank you. As I may have mentioned in my opening, addressing these issues has been the driving force of my career. It's the reason that I went to law school. We are way past the listening stage. We are way past the stage of saying that this is about respect. What we're talking about here is communities of color, Black, Indigenous people of color, communities that I come from, raging in the streets in order to be heard. That's not the time where we sit down around a conference table and have a conversation about how people like me have not been heard. I've been criticized throughout this campaign for being express about bringing a new voice to the Washington State Supreme Court. I bring that new voice because I believe it to be foundational that if we are going to address structural inequities and change structural inequities, that we have to be honest about the foundation upon which our legal system is built. The fact that we have extraordinary disproportionality of Black men incarcerated, of Native children in the foster care system, is not a flaw in the system. It is a feature of the system. The system is working the way it was intended when it was built. And we have to talk about that in order to fix it.
Thank you. Judge Larson, you're up. Looks like you're muted still.
I knew I'd do that once. So it looks like the time for talk is over, as indicated. As I indicated previously in my opening remarks, for years the judiciary has had studies and task force and commissions and everything else, and nothing changes. The system right now reinforces and aggravates racism that's in our larger society. When you come into the system, you're greeted in a way that tears you down instead of builds you up. And so is it any wonder people don't trust our system? Now, the idea of respect and dignity comes from a thing called procedural fairness, which is something I've been trying to get into the courts for quite some time, training on procedural fairness. It applies across the board. But the idea, and you can watch a video on my Facebook page from a guy named Lamont Stiles, who talks about being in my court and the difference and the impact it has on people when they're treated differently. And when the system's wired to punish you from the get-go, it's no wonder that it aggravates and reinforces racism. We've known it for a long time, but we don't want to change it. And that's what has to change. We have to start with a therapeutic approach. I wrote a strategic plan in 2018 on therapeutic approaches, and wrote a paper last year called Justice Involved Therapeutic Intervention that applies across the board, whether it's regardless. But the point is if we greet people of color in the court system in a way that's constructive for their lives and shows them a better way, then we're going to be a lot better off. And until that structural change happens, all the talk in the world ain't going to change anything.
Thank you. Our next question, and the first person to answer on this will be Justice Montoya-Lewis. What actions have you personally taken to address your own implicit biases?
That's an excellent question. And I will just start by saying, if you're going to be someone who purports to be a national expert on implicit bias, you better know your own. And I think that takes serious inward thought and consideration about your biases. But much more important is being willing to have very hard conversations about what you think with people who are willing to be honest with you about where your biases are impacting your decision making. I've done that work privately. I've done that work publicly. I've done it in my trainings as a means of training other judges as a model of how that might look. Procedural fairness is something that Judge Larson said he wanted to get into the courtrooms. I've trained on procedural fairness, and it has been in courtrooms all over the country for years. What that means, if you really have it, is that you have judges who not only understand that their biases impact their decision making, but seek out training in order to address it and become better at recognizing those things. That's work that I've done internally, and it's work that I will commit to continuing to do externally as well.
Thank you. Judge Larson, you are next on that.
Well, procedural fairness has been talked about for years. And the question is it prevalent in our courts? And the answer is no, from a standpoint of people of color. And I think the best test for me, because the nature of implicit bias is I don't know that I'm having the bias at the time. I guess the best evidence for me is when I ran for office in the first editorial board I appeared in front, it's not editorial board, endorsement board I appeared in front of was in my own community, the 30th district. And the first time this black lady spoke to me, she said, "Thank you for what you do for the Black community in Federal Way." When the George Floyd incident occurred, I did not, I understood that I had the trust and confidence of the Black and brown community in Federal Way. I did not know how much until after that. And the love and respect they have for me in terms of how I conduct my business and how I treat people in court, that's the best evidence in terms of the idea of implicit bias, because I can't be a judge of my own implicit bias. Other people can. And that's the best evidence. Now, how did I accomplish that? Because I did my job the best way I could. I treated people fairly. I treated people based on facts. I listened to people. I heard people. I treated them with respect. And it's not something that to downplay in terms of how somebody's treated, because that's exactly what the impact is going to be. How somebody's treated is how it's going to be perceived by the person on the receiving end.
Thank you. Dr. Serns, you're up.
I finished my career in a small school district where I was superintendent, but I spent 11 of my years of my career in the Federal Way School District, which I mentioned earlier has about 23,000 students, 2,500 employees, and well over 100 different languages spoken. It's one of the most diverse districts in the state, and if not the entire country. So in that capacity, in that role, we had continually to train on cultural competence. I probably individually went to at least a half a dozen different trainings. And one of the things that I don't feel that I was intentionally biased at all, but there's this implicit bias. And one of the things that I always teach in the training is you don't know what you don't know. And so it's very important for all of us to continue to try to do that. And with over 100 different languages and cultures, it's not about just one, or, there's so many nuances to it. And of course, within cultures, there's many differences too. So we need to always be learning. One thing I've done this summer, I know it's been out for several years now, but I watched the movie 13th, which I've been trying to encourage everybody to watch, about the history of the systemic racism in our judicial system and in our country as a whole. And so I think we just need to constantly be learning. I've had a lot of experience in this. I've helped other people train, but it's something we all need to continually improve on.
Thank you. Okay, we are on to our final question. And for this one, Judge Larson will be the first person to answer this. So for the final question, impartiality is a hallmark of any judge's position, yet impartiality meets barriers when dealing with the power dynamics of wealth, class, race, and more. How do you intend to be impartial without inadvertently supporting those with the most institutional power?
Well, first of all, the way I view power, it shouldn't be about power. It should be about responsibility. Because if it's about responsibility, it's about the role you play and what you owe to others rather than what people do for you. The more power you get, the more humility you need. I'll tell you a story. I hope I can tell it in the time that highlights that. I was in a panel of 6 elected officials in front of some high school students. And one of the high school students asked, when would you feel closest to your position? And they went down the line, mayor, city council, legislators, and talked about something they did in their official capacity. When it got to me, I talked about being at the end of a line at a chili cook-off at farmer's market, which is kind of strange. But the story is that somebody came up to me and said, "Hey, Judge, how you doing?" And I said, "Fine," and talked to them for a couple of minutes, and they left. The person behind me then said, "Hey, you're a judge. You can just cut up in the front of the line and get in now." And I said, "Actually, when I have my robe off, I'm like anybody else." Because the more responsibility you have, the more humility you need. Because if you don't, you'll get exactly what we're experiencing now, where it's all about power. It's all about control. It's all about getting my way. I operate by 2 rules. Love the freedom of others as much or more as you love your own. And it's more important to do right than to be right. If that drives you, then the power dynamic and everything else won't be there. And everybody assumes just because I'm a white male that I came from a well-off background. I didn't. my family's on food stamps. I had to work when I was 12 years old to help make the house payment, et cetera. So there you go. My time's up.
Thank you. Dr. Serns, you're next on that.
I'm really glad you asked this question. I think it's an important one. And of course, wealth and race, class are huge issues that need to be addressed. And the more it is also includes partisan positions and special interest groups. One of my passions is to truly be nonpartisan. We're required to be nonpartisan when we run for judicial office, but I'm nonpartisan even when I'm not running for judicial office. In our state, I'm really proud of the fact and happy that we elect our Supreme Court justices, and it's supposed to be nonpartisan. And you're supposed to be appointed only if someone dies or is incapacitated or reaches the age of 75. But 5 out of 9 of our current justices on the Supreme Court were appointed because a justice resigned early, presumably so that the governor then could appoint somebody and they get to run as an incumbent. We very seldom have the opportunity to run for an open seat. I was asked why I'm running against the person I'm running against. I said I would have much preferred running for an open seat, but we rarely have that opportunity. And this isn't a Republican Democrat issue. I don't care who the governor is. It shouldn't be partisan. In addition to that, I have accepted no donations. I have not sought any partisan endorsement. You can see on my website that being nonpartisan and truly not influenced by any of these factors is one of the hallmarks of my campaign.
Thank you. Justice Montoya-Lewis, go ahead.
Thank you. The photograph that you should see behind me on the background is a photograph of me signing the oath of office when I was sworn in as a Supreme Court justice. The reason I show that picture is that you may be able to see in the photograph that I wear a feather in my hair. It's a traditional thing that many Native people do when in ceremonial occasions. In brief, I will tell you that I served as a tribal court judge for my own community. I refused to make a decision I was directed to make by the government of my own community. And as a result of that, I lost everything. I lost my job. I was disenrolled from my community, which meant that I couldn't own property and therefore couldn't live in the house that I owned. And I could go on about the other consequences that fell from that, but they were serious and severe and continue to this day. Although recently I re-enrolled in my tribe after being asked to do so. Impartiality is fundamental to being a judge. Judge Larson suggested recently that because I'm proud of who I am, because I have said that it is time for there to be a Native voice to have a seat at this table, this most important table, that I can't be fair. I assure you I can be.
Thank you all so much. So that's all the time that's all of our prepared questions. And typically right now we would go to questions from the viewers, but we have not had anyone drop those in the chat right now, and we are pretty close to the end. So what I would like to do instead is give each one of you 1 minute and 30 seconds to do a closing statement. So we can go ahead and start with Judge Larson and take it away.
Okay, so I'll just, again, I'll start with the same thing I talked about in opening. It's a passion I have for helping the people that we're supposed to be serving that aren't being served, the people we're failing. That's why I ran for the Supreme Court. Now, Justice Montoya-Lewis wants to make a big deal out of the fact that I've run before and that I've said that I'm not running against somebody, I'm running for the position. I stick with that. I stick with that to this day because I care about the judiciary. I love the judiciary. I love what I do. I love what the legal profession can do for people. And I think I can have a voice on the Supreme Court that'll make a difference for the people of the state. Now, what I actually said about Justice Montoya-Lewis is that I think in terms of her heritage, We have done horrendous things to the Native Americans in this country, and the things they've had to overcome are significant. So I agree with everything she says. The fact that she got the position is wonderful. Where the problem she's speaking of is when she puts on her website that she's the voice for Native Americans and the underserved. As that's good for a legislative position, but for judiciary, we're on nobody's side. The thumb shouldn't be on the scale for anybody, no matter how popular that particular party is. And so, and I know it's might be upsetting to people, but the thing is the judiciary should not be a place for anybody's, because anybody that comes to court should feel they're being treated fairly, and that you're not anybody's voice other than the law and the Constitution. That's the voice of a purist, and I know it's not popular, but the bottom line is that from a judicial standpoint, you're waving it. I took my eye off the timer. I apologize.
No problem.
So thank you very much. I appreciate it.
No problem at all. All right, Dr. Serns, you have a minute and 30 seconds for a closing statement.
All right, again, thank you for this opportunity. I mentioned I have a very unconventional career path toward this position. Some have considered that a weakness. Others actually consider it a strength. I've said before, if all 9 justices had my experience, it would probably be a weak court, but I would offer that if all 9 justices had the experience of any one of them, it would be a weak court. So what I bring is something that's a fresh perspective, a new set of eyes. I do feel my job experiences and the things I've done for the last 20 or 30 years serve me well for the role of working as a Supreme Court justice. The fact of listening carefully, asking probing questions, studying research, building consensus, deliberating with colleagues, and making a fair and just decision. And as I mentioned earlier, reviewing hundreds of laws at the state and federal level. I think it's important to have diversity of thought and experience, as well as other types of diversity. I often say that I'm running for the public office like applying for a job. I too am not considering myself running against Justice Whitener. I think has excellent qualifications. She's a very good justice. I just offer myself as an alternative, and would be happy if you'd consider me. Thank you very much.
Thank you so much. Justice Montoya-Lewis, go ahead.
Thank you. The photograph that you see behind me is a photograph from about 1885 of the Carlisle Indian boarding school, where Native children were sent without their parents' consent, put on trains from all over the country to Pennsylvania, where they were beaten for speaking their language, had their hair cut, had their traditional clothing removed, and were forced to wear military uniforms, among other things. My great-grandmother went to Carlisle boarding school, and institutional care has been a part of my family's history all the way up until you get to me. The idea that I could be sitting on any state Supreme Court is an extraordinary one, and one I can't imagine that any of my ancestors who suffered and died and suffered and lived for me to have a life could have envisioned. I'm running for this position because I have lived the experience of being a person of color in this world, in this state. I have lived the experience of being a judge for courts that had no funding, courts that had little funding, courts that had plenty of funding. I've been a therapeutic drug court judge for many years. I've been a professor for many years. You could not find a more qualified candidate for this position.
Thank you all so much. I really, really appreciate all of you taking the time to speak with us tonight. This segment of the forum has been fantastic. So that is it for this section of the forum. And then next up, we will
Can I say again, I emphasize this is one of the most professional, and I don't know how the other folks feel, one of the most professional forums we've had. So it's very much appreciated.
Thank you so much. We really appreciate that. For everybody who is watching live right now, I'm going to drop the websites of all of the candidates here in the chat. And I'm also including the website for Dr. Serns' opponent, Justice G. Helen Whitener, so that you have all of those to look into more thoroughly. Once again, thank you all so much.
Thank you.